The appellant has challenged the lower court's decision to order his extradition and surrender to the U.S. for trial. Counsel for the appellant at the hearing of the appeal abandoned all other grounds of appeal and mainly argued the issue as to whether, in the absence of an extradition treaty between USA and Kenya, Kenya can lawfully extradite a person to the USA. The state opposed the appeal, arguing that even though there is no bilateral treaty between Kenya and the USA allowing extradition of persons between the two states, Kenya could still extradite the appellant on the basis of Article 6 of the United Nations Convention Against Illicit Trafficking in Narcotic Drugs and Psychotropic Substances, 1988. The country, Kenya, having acceded to the convention on the 19th of October 1992, became bound by its provision, thus the country cannot run away from its obligations under the convention. The state also cited the provisions of Article 2, 5, and 6 of the Constitution and argued that the general rules of international law and any treaty or convention ratified by Kenya, and I emphasize convention, ratified by Kenya shall form part of the law of Kenya under this Constitution. The state, having acceded to the convention, was therefore bound by its provisions and by dint of Article 2, 6 of the Constitution could not avoid the obligations arising under the convention. Article 6 of the United Nations Convention Against Illicit Trafficking in Narcotic Drugs and Psychotropic Substances, 1988, provides, and I quote, extradition, that is the heading. This article shall apply to the offenses established by the parties in accordance with Article 3.1. Each of the offenses to which this article applies shall be deemed to be included as an extraditable offense in any extradition treaty existing between parties. The parties undertake to include such offenses, extraditable offenses, in every extradition treaty to be concluded between them. 3. If a party which makes extradition conditional on the existence of a treaty receives a request for extradition from another party with which it has no extradition treaty, it may consider this convention, and this is important, it may consider this convention as the legal basis for extradition in respect of any offense to which this article applies. The parties which require detailed legislation in order to use this convention as a legal basis for extradition shall consider enacting such legislation as may be necessary. Number 4, the parties which do not make extradition conditional on the existence of a treaty shall recognize offenses to which this article applies as extraditable offenses between themselves. Extradition shall be subject to the conditions provided for by law of the requested party or by applicable extradition treaties, including the grounds upon which the requested party may refuse extradition. In considering requests received pursuant to this article, the requested state may refuse to comply with such requests where there are substantial grounds leading its judicial or other competent authorities to believe that compliance would facilitate the prosecution or punishment of any person on account of his race, religion, nationality, or political opinions, or would cause prejudice for any of those reasons to any person affected by the request. The parties shall endeavor to expedite extradition procedures and to simplify evidentiary requirements relating thereto in respect of any offense to which this article applies. 8, and this I emphasize, subject to the provisions of its domestic law and its extradition treaties, the requested party may, upon being satisfied that the circumstances so warrant and are urgent, and at the request of the requesting party, take a person whose extradition is sought and who is present in its territory into custody, or take other appropriate measures to ensure his presence at extradition proceedings, without prejudice to the exercise of any criminal jurisdiction established in accordance with its domestic law. A party in whose territory an alleged offender is found shall, A, if it does not extradite him in respect of an alleged offense established in accordance with Article 3, Paragraph 1, on the grounds set forth in Articles 4, Para 2, subparagraph A, submit the case to its competent authorities for the purpose of prosecution unless otherwise agreed with the requesting party. Now I go on and on with that article. This court has considered the rival arguments by counsel in this matter. Whereas the appellant strongly holds the view that a treaty is a condition sine qua non to any extradition arrangement between Kenya to the USA on the basis of existing provisions of Section 3 of the Extradition, Contiguous and Foreign Countries Act, the appellant has not addressed this court on the fate of requests lawfully received by the Central Authority of Kenya where no treaty or bilateral agreement exists. Listening to the arguments made by the appellant's counsel, one gets the impression that once the 1931 treaty between the UK and the USA was terminated, Kenya was left in a position that it could not extradite anyone to the USA regardless of the offense involved. The court notes with appreciation the submissions by both counsel for the parties in this matter. The one thing that neither counsel addressed this court on was the application of Section 7 of the 6th schedule to the Constitution in construing the provisions of the Extradition, Contiguous and Foreign Countries Act, Cap 76, insofar as the same relates, relates to extradition under the framework of the Constitution of Kenya 2010. This country having evolved to recognize the place of international law as being part of our law, a lot has changed because the application of municipal law has to be undertaken with the country bearing in its mind obligations under international law in relation to the treaties and conventions that we are party to. The 1931 treaty was concluded between US and the UK, who were our colonial masters. We continue to apply the treaty after we attained independence up to the time the same was terminated. However, Kenya as a sovereign state was at liberty upon the attainment of its independence to chart its own path upon termination of the treaty. The argument by the appellant that since there is no treaty, Kenya cannot extradite anyone to the USA, if accepted, would mean that there is a vacuum in law. The law abhors a vacuum, and by necessary implication, the promulgation of the Constitution of Kenya 2010 opened a new chapter on the application of international law in Kenya. Kenya is a party to the 1988 United Nations Convention against illicit traffic in narcotic drugs and psychotropic substances, and is therefore under an obligation to give effect to the provisions of the convention. It does appear that the framers of the convention were alive to the fact that certain countries, including Kenya, would require an extradition treaty before they could extradite persons required for prosecution in other states. Thus, the inclusion of Article 6 in the convention to specifically deal with extradition. The article is applicable in Kenya. By dint of Article 26 of the Constitution of Kenya, as read together with Section 7 of the transitional clauses to the Constitution, which permits the construction of any statutory provisions with the necessary modifications and alterations to bring it into conformity with the Constitution. The country performs its obligations under international law on the basis of reciprocity. Thus, where Kenya is a signatory and has ratified or acceded to any treaty and or convention, it cannot avoid its duties under that treaty or convention. The principal pacta sunt servanda would frown upon any suggestion that simply because there is no bilateral arrangement between the two states, then Kenya should not extradite. We would be subject to international condemnation if we were to adopt such a position. In Director of Public Prosecutions versus Okemo and four others, this is what the Supreme Court said. The extradition request was made and acted upon pursuant to Section 7 of the Act, the Mutual Legal Assistance Act, the London Scheme of Extradition, the revised scheme relating to mutual legal assistance in criminal matters within the Commonwealth. The extradition process was commenced based on laws and policies that were based on international agreements that did not fully fall under the purview of domestic criminal law. The criminal aspect of the judicial phase of the extradition began with the forwarding by the AG of the authority to proceed to the DPP for commencement of the committal proceedings. Now, I underline the following. Extradition proceedings were effected by international considerations, including bilateral and multilateral agreements with the states to extradite persons considered to have committed extradition offenses. These international agreements consisted of essential conditions in the extradition process. The international agreements constituted the civil elements of extradition. An extradition proceeding, unlike a criminal proceeding, was founded on the concepts of reciprocity, comity, and respect for differences in other jurisdictions. End of quote. The offenses for which the appellant is required are offenses that are extradition offenses in our country. Thus, the principle of dual criminality is satisfied. The only option open to Kenya, having received the request from the USA, is to prosecute or extradite the appellant in line with the principle of aut dedere aut judicare. At the hearing of the appeal, the state did not express any wish to prosecute the appellant, and they remained forthright that the intention by the state was to give effect to the request by the US authorities. In view of the fact that there were no arguments on any bar to extradition, any bar to extradition, this court shall not delve into such matters. The court in Groschoki, I can't pronounce this name very correctly, versus Attorney General. This is a decision by the High Court of Kenya, rendered by the late Justice Njagi, and he said this. It is my respectful view that this approach covers the concerns raised by Mr. Amolo. What I understand it to mean is that if Kenya makes extradition conditional on the existence of a treaty as espoused in the dualist doctrine, and if Kenya receives a request for extradition from another party like Belgium, with which it has no extradition treaty, it may consider this convention as the legal basis for extradition in respect of any offense under this article. Since the convention can be used as a legal basis for extradition where there is no extradition treaty, as in this case, then I find that the order for extradition was granted by the Line Chief Magistrate was well-founded and lawful. For that reason, this application must fail, and it is accordingly dismissed. It is so ordered. That was the decision by Judge Njagi dealing with a situation where Belgium sought extradition from Kenya and there was no treaty between the two countries. He rejected the arguments that the extradition could not happen. Similarly, in the instant case, the state has chosen to rely on the convention as the basis for extradition. The convention provides for extradition between all states. To the convention, thus Kenya does not expressly require an extradition treaty between her and the United States of America to extradite anyone either to or from the USA in connection with matters covered under the convention. The country, having acceded to the convention, expressed its willingness and commitment to abide by the convention provisions and to perform all its obligations under the convention. The Central Authority of Kenya under the Mutual Legal Assistance Act is the Attorney General, and having received the request from the U.S. authorities and granted his seal of approval by transmitting it to the DPP, who is the competent authority for action, it matters not that the USA authorities had quoted the 1931 treaty as a basis upon which the request was made. The Honorable Attorney General, having received the request and acted on it as the principal legal advisor to the government of Kenya under Article 156 of the Constitution, acknowledged the request to be proper, and the wording of the request in its introductory part would properly pass as purely a defect in form but not substance. The position in Kenya changed after attaining independence, thus any reliance on agreements and or treaties concluded between the UK and other states when Kenya was still a colony would give way to the application of newly negotiated documents between Kenya as a sovereign state, such as the 1988 Convention. Malcolm N. Shaw, in his book International Law 9th edition at page 834, writes, and I quote, "Political entities are not immutable. They are subject to change. New states appear and old states disappear. Federations, mergers, dissolutions, and secessions take place. International law has to incorporate such events into its general framework with the minimum of disruption and instability. Such changes have come to the fore since the end of the Second World War and the establishment of over 100 new independent countries. Difficulties may result from the change in the political sovereignty of a particular territory and territorial entity for purposes of international law and the world community. For instance, how far is the new state bound by the treaties and contracts entered into by the previous sovereign of the territory? Does nationality automatically devolve upon the inhabitants to replace that of the predecessor? What happens to the public property of the previous sovereign? And to what extent is the new authority liable for the debts of the old? States' succession in international law cannot be confused with succession in municipal law, and the transmission of property and so forth to the relevant heir. Other interests and concerns are involved, and the principle of state sovereignty, equality of states, and non-interference prevent a universal succession principle similar to domestic law from being adopted. Despite attempts to assimilate Roman law views regarding the continuity of the legal personality in the state which falls by inheritance, this approach could not be sustained in the light of the new state's interests and practice. The opposing doctrine, which basically denied any transmission of rights, obligations, and property interests between the predecessor and successor sovereigns, arose in the heyday of positivism in the 19th century. It manifested itself again with the rise of decolonization process in the form of the clean state principle, under which new states acquired sovereignty free from encumbrances created by the predecessor sovereign. End of quote. The clean state principle would allow Kenya to commit itself within the international arena without having to resort to treaties concluded long before its independence with other states, more so where the constitutional landscape has radically mutated to embrace international law as part of our law. The duty to cooperate by states in international law is key to the implementation of multilateral treaties and conventions. The cooperation that the USA seeks from Kenya in the instant matter is permissible in law by dint of Article 6 of the 1988 United Nations Convention. It would be against the spirit of international cooperation to decline the request that the words of the convention are expressed on matters extradition, absent of any evidence that the appellant may be subjected to prosecution and punishment on account of his race, religion, nationality, or political opinions, or subjected to torture. As a result, this court finds that there is sufficient legal basis for the extradition of the appellant to the USA to face trial. The appeal therefore fails in its entirety and is hereby dismissed. It is so ordered.
With my friend Mr. Witty on many things. The only thing I don't agree with is the team he supports. He supports a third-rate team called Arsenal. No, my lord, it's a long judgment.
Yes.
I'd like to have a look at it.
Yes.
Perhaps the request I'll make is the request for type proceedings to be able to quickly take instructions on the way forward. I know I have a right of appeal within 14 days. Within that period, I think we should have made up of our mind.
Thoroughness of the judgment from what I've had you read through. Maybe I should have started with Mr. Onge not having any team, and we are number one. But thank you for the thoroughness of the judgment and the reference to the clean state. That's new to me, and the student in me is happy about that. I'll also take time to read through. I think we have done a lot in terms of this particular litigation because there are at least 2-3 matters where references have been made to Mr. Oonge's brave attempt at this, which we appreciate him for. And therefore, I appreciate both Mr. Onge and the court for what the Constitution obligates all of us to do, which is to help in the development of the law. So we appreciate and ask humbly for a copy of the judgment. We thank you.